Hello and welcome to Muckle LLP's webinar on disqualification, including by association. My name's Amy Sergison and I'm an Associate Solicitor in the Employment and Education team at Muckle, and I'm joined by Jill Donabie, who's also an Associate Solicitor in the Employment and Education team at Muckle. So we're here today to talk about the childcare disqualification requirements. These are not new requirements and they're set out in the Childcare Act 2006 and the Childcare Disqualification Regulations 2009. They only were clarified as applying to primary schools over the autumn, and the reason was that the early years foundation stage was extended on the 1st of September 2014 to include primary schools, which suddenly brought primary schools within the remit of this legislation, which had historically only applied to nurseries and childminders. So the DfE produced a document, Keeping Children Safe in Education, Childcare Disqualification Requirements, Supplementary Advice, October 2014, a bit of a mouthful, but that came as somewhat of as an afterthought. So there was no forewarning to schools that these requirements were going to apply to them from September, and the supplementary advice itself was actually pretty ambiguous and unclear. It left an awful lot of confusion for primary schools as to who the requirements applied to and what their obligations were. And from talking to schools, we know that there were a lot of mixed messages given from local authorities, trade unions, Ofsted, and even from the Department of Education themselves. So at the time that we were given this supplementary advice from the DfE, there was obviously a lot of confusion about what was going to happen in the future, and we were promised further guidance from the DfE on the requirements, but we weren't given any kind of timescales. As a result of that, many schools just weren't sure what to do. We know that some chose to deal with the requirements by dealing with things immediately and implementing them and interpreting the legislation as they thought fit. Some decided not to do anything and wait for clarification from the DfE before they even started to apply the requirements to their schools. So it was quite a confusing time for people. We're going to come on shortly to look at the regulations in more detail and how they do apply, but it's probably worth and quite helpful for you just to understand at the moment what we understand the current statistics are for people who have made referrals for and applications for waivers from Ofsted. So we know that at January 2015, which is probably when this issue started to hit the press and schools started to become very aware that these regulations and requirements applied to them, there were approximately 300 members of staff in schools nationwide who'd been suspended from work, pending Ofsted considering their applications to waive disqualification. After the supplementary advice was given, then we had all of the confusion that followed that, and we know that up to 2 weeks ago, the number of employees suspended had quadrupled. So Ofsted confirmed that on the 27th of February, they had received 1,009 applications for a waiver, and at that time they had only processed 599 of those applications, but they had granted 228 waivers where it was appropriate, and they deemed that 271 which had been sent in actually didn't fall under the legislation and so didn't require one. So it was clear at that stage that there was still a lot of people and schools who understandably were very confused as to the circumstances in which the childcare disqualification requirements applied and to who. So what's happened since then? Well, helpfully on the 26th of February 2015, the DfE has issued further statutory guidance, so schools are bound to follow this guidance. This is called Disqualification under the Childcare Act 2006, Statutory Guidance for Local Authorities, Maintained Schools, Independent Schools, Academies and Free Schools. Thankfully, this has given us an awful lot of clarity over the requirements and the situations in which the legislation is going to bite. So we understand that the guidance is set to be reviewed again in September 2015, but at the moment this should hopefully give schools a much clearer steer on what their obligations are in relation to the legislation. So what are the implications of employing someone who is disqualified, including by association? That is just the same as it has been. It remains a criminal offence to knowingly employ someone who is disqualified from working with children, including by association. So during this webinar, we plan to talk about what is covered, who is covered, which we've had a lot more clarification on, what disqualification is, what the next steps are, and what happens in the worst case scenario. First of all, what is covered? We've got three different limbs here. Staff are covered if they provide early years childcare, so that is childcare up to the 1st of September after a child's 5th birthday. Later years childcare, so that's for children who are over 5 but under 8, or staff who are directly concerned with the management of that childcare. So the management of that childcare is fairly easy to identify. You'd be looking at the head teacher and potentially most of the senior leadership team within a primary school. For early years provision, that will include staff who provide care for a child up to including reception age. So that's going to bite for your nursery and reception class teachers and anyone who's involved in a supervised activity. So for example, breakfast clubs, lunchtime supervision and after school care. Later years provision is for children under 8. Later years does not include education and it doesn't include extended school hours, so any co-curricular learning activities like school choir or sports teams, that is not included in later years provision, but before and after school provision, so breakfast clubs, will be expressly included. So who is covered by the legislation? We've had a lot of clarity on this because this was an area of big concern for schools when the requirements originally came out and the supplementary advice came out in October. So we now know that teaching staff, teaching assistants and volunteers providing childcare in nursery and reception classes are included, which is what we thought. When the supplementary guidance came out in October, this was one of the areas that caused the most confusion, as the definition of providing childcare, as it was, wasn't drilled into in any details. So many schools just took a bit of a blanket approach and chose to err on the side of caution and just assumed that anyone who came into contact with children under the age of 8 fell within the scope of the requirements, and so we're planning to deal with them accordingly and seek information from them. But thankfully, the statutory guidance is a lot more prescriptive and tells us specifically that there are exclusions. So excluded from the legislation are caretakers, drivers, cleaners, transport escorts, catering and office staff, but bear in mind that lunchtime supervisors will potentially still fall within the definition if they are providing childcare. We also know that anyone involved in healthcare provision for a child, so school nurses, local authority staff such as speech and language therapists and educational psychologists, are also expressly excluded. The guidance even goes so far as to say that if a member of staff is only occasionally deployed into early years provision for education or later years, then it doesn't necessarily follow that they will automatically come within the scope of the legislation. The statutory guidance says that schools would need to exercise their judgment in that situation, and this would depend upon the facts and circumstances of the individual's role. It's worth in that situation taking advice if you aren't sure, because that's not always going to be clear cut. We do also know that governors are excluded unless they also volunteer and work in a relevant childcare sector on a regular basis or they're involved in the day-to-day management, but for the majority they aren't going to be covered. So what is disqualification? Disqualification happens automatically. That means that an individual could be disqualified and not know about it. There are several grounds on which an individual could be disqualified. So how can an individual become disqualified? If they are included on the Disclosure and Barring Service Children's Barred List, that is an automatic disqualification. If they are found to have committed certain violent or sexual offences against children or adults, either in the UK or overseas, again, they will automatically be disqualified. The list of offences we'll come on to shortly, but that is listed in the statutory guidance. In fact, it takes up a vast chunk of the guidance itself, and it's also in the legislation. An individual, if they have certain orders made in relation to the care of children against them, they could also be automatically disqualified. If they are refused or have any registration relating to childcare cancelled or are prohibited from private fostering, they could be automatically disqualified. And crucially, where the majority of concern has come from this law, if they live in the same household where another person who is disqualified lives or is employed, this is the disqualification by association element, they could also be disqualified. So the disqualification by association element is clearly very wide. It is anyone who lives or is employed in that household. So it's going to catch spouses, children, parents, foster children, and it could actually go so far and will include housemates. So even where an individual is in a professional house share, their housemates or flatmates are also going to be included in that. In terms of being employed in the household, this is going to catch au pairs, nannies, and perhaps even cleaners. So it is really, really wide-reaching. And again, the importance and the reason that we need to know about this and to deal with it is that it is a criminal offence to knowingly employ someone who is disqualified, and that includes this by association element. So what are the offences that could cause someone to be disqualified? If we just park for a moment all of the other ways in which someone can be disqualified. These are listed in the legislation, they're listed in Ofsted guidance. As I mentioned, they take up a chunk of the statutory guidance, and the list is huge, and to be honest, when you read it, it makes for some pretty terrifying reading. There are some really horrible offences on there. They include serious allegations of sexual crimes and violence against children and adults, but also perhaps at the lower end of the scale in terms of severity, it also includes actual bodily harm. So actual bodily harm would cover the type of situation where someone got into a fight and gave someone a bloody nose. That is potentially actual bodily harm. So in the context of the severity of some of the really serious and awful offences that are listed there, that's probably one of the least serious. And in that context, it could potentially touch a lot more people. So under the legislation, a person is disqualified if they are found to have committed a relevant offence that's listed in the legislation, or if after the 6th of April 2007 they have been given a caution, reprimand or warning for one of the relevant offences. As I've mentioned, it's a very broad scope and will pick up a lot of offences. So what should schools do? There is an obligation on schools to ensure that they aren't knowingly employing someone who is disqualified. The statutory guidance says that anyone who falls within the relevant categories of staff should be made aware of the legislation, including the fact that they could be disqualified by association. So what schools practically need to do is do a tally up of which staff members and volunteers and anyone else who provides childcare within the school to children and in a relevant setting are affected. We know that when we had the supplementary advice that came out in October, many of schools who chose to err on the side of caution just considered everyone and had a list of everyone who ever walked past a child under the age of 8. And we also know that a lot of schools are now going back and reviewing that letter and streamlining that down in light of this legislation. And it's probably sensible to do that because you don't need to go further than the law requires. And that could open a can of worms in terms of data protection issues, which we'll come on to consider shortly. But how practically should a school obtain this information? Schools are free to decide how to make staff aware of what is required of them, but many of them are choosing to issue a self-declaration form to ask for this information. So the declaration form is to be signed by all staff who fall into a relevant category in relation to themselves and in relation to household members. We have prepared a declaration form, and if anyone would like to have a copy, you'll see our details at the end, please just let us know. But this expressly sets out and clarifies that we get the information from staff members that we need in order to take a decision as to whether or not they are disqualified. But one thing that we need to be careful about, and what a lot of commentary in relation to the clarification on the disqualification requirements has been about, is issues under the Data Protection Act 1998, potential human rights issues, and the Rehabilitation of Offenders Act. So data protection issues, care needs to be taken when schools are using a self-declaration form, and questions need to be relevant and limited only to the requirements of the legislation. If a school asks for information beyond this, this could be a breach of data protection legislation. And additionally, if a school is asking for disclosure of DBS checks, medical records and anything like that, particularly in relation to third parties, this could also be an enforced subject access request under the Data Protection Act 1998, and as of this week that is now also a criminal offence, so care needs to be taken in relation to this. It's worth letting staff know what their obligations are and what information you are seeking, and if general questions are asked about certain types of offences, it would be worth clarifying to staff the offences which are on the list and need to be disclosed before getting information that you don't need and potentially breaching data protection legislation. So staff should be told that they aren't to disclose details of any protected caution or convictions or spent convictions for the purposes of the Rehabilitation of Offenders Act 1974. And we're not going to go into detail about the remit of the Rehabilitation of Offenders Act because we could probably talk for another hour on those obligations. But in the context of many of the offences which are listed in the legislation, that it's probably not ever going to be an issue, but it's just worth bearing in mind and letting staff know that they don't need to go beyond that, and indeed if they do, that might give you a bit of a data protection headache. So schools also should be careful about how any of this data is stored, as again there are potential infringers of data protection legislation, and if you aren't sure, take advice on this. I'm now going to hand over to Jill Donabie, who's going to continue looking at this issue in a bit more detail.
Thanks, Amy. Amy's already mentioned about identifying relevant staff and has outlined the suggestion that you issue a declaration to those relevant staff to elicit the information required in order to establish whether an individual will or will not be disqualified. You may also want to undertake a process of auditing personnel files, again just in relation to those relevant staff. We'd also suggest that you inform them of their ongoing duty to notify of any changes, and we'll come on shortly to some suggestions as to additions or amendments you may want to make to your contracts of employment, this being one of them. The responses that you receive to the questions that you've asked, there is no duty to investigate those answers. So unless you know them to be incorrect or dishonest, we would suggest that you take the answers you're given at face value. We'd also suggest that you reissue these forms regularly in order to establish whether there have been any changes, and we'd suggest that you either do that annually or perhaps every 2 years. Similarly, we would suggest that you amend your recruitment policy, including your safer recruitment policy, and have this as part of your pre-employment checks. You should also include it as part of your induction process. It may be wise that you have this as a condition on an offer of employment in the same way you may have receipt of satisfactory references. You may also want to update your safeguarding policy to include this. In terms of the contracts and some changes that you might want to think of, the first would be a warranty from the individual confirming that they are not disqualified from teaching under these regulations or from being involved in work in this context. You may also want to go further and perhaps impose an obligation to do the following: complete a declaration regularly, to answer the declaration to the best of their knowledge and belief, to notify the head or some other nominated party immediately if they become disqualified, including by association during their employment, and you may also want to consider whether some kind of requirement to apply for a waiver in the event of disqualification is necessary. You should also be keeping records of this as part of your single central record. And moving on to the worst case scenario. If there is no relevant disclosure, then no action will be required. However, should someone have answered yes to one of the questions on the declaration, the next thing you should do would be to establish whether that offence appears on the Ofsted list. If necessary, or if you're in doubt, take advice. If it's not on the list, then you should be okay to proceed. However, if it is on the list, the individual will be automatically disqualified, and as Amy has already explained, it's an offence to employ someone who is known to be disqualified from working with children. You would have 14 days within establishing this to notify Ofsted that this is the case. The individual is the one who has to make the application to Ofsted. It's not something which can be done on their behalf by the school, although the school can sometimes submit supporting evidence to accompany that waiver application. The individual should give the date and the nature of the offence, the court who had imposed the offence, and a certified copy of the order. There is an email address contained in the statutory guidance to which individuals can send requests for a form. There's also an Ofsted fact sheet which gives some guidance on applying for a waiver. Unfortunately, there's no prescribed time limit for Ofsted to respond, and that will always depend on the facts and circumstances of the application. The types of things that we understand Ofsted will consider are the reasons for the disqualification, the nature and severity of the offence and when it took place, the reason why the individual thinks that the disqualification should be waived, the risk posed to children, any information provided from third parties such as the police or local authority, and any other mitigating factors. So whilst we're waiting to find out the outcome of this waiver application, which as we heard at the outset can take some time, it's necessary to consider as an employer what the next step should be that you take. Of course, it would be an offence to have the individual working in that relevant setting, and so you need to consider alternatives. For example, can the individual be redeployed to a position where there is no contact with young children? If you are part of a multi-academic trust or perhaps a group of nurseries, for example, then you would have to consider wider than your own individual organisation. You should also give some thought to the alternative working arrangements. Could work be structured to avoid them working in a restricted setting? For example, could they work from another building where the children are all over the age of 8? Or could they even work from home, depending on the role that they do? Suspension should always be a last resort, and another option would be paid leave. You always have to be careful when instituting any kind of suspension that you don't undermine the mutual bond of trust and confidence which underpins every employment relationship. A knee-jerk suspension without considering these alternatives could potentially breach that mutual bond of trust and confidence and expose you to a risk of a constructive dismissal claim. If you do suspend, you need to make sure that you take all steps you can to minimise the impact on the staff member as much as possible. Assuming that you do go ahead with a suspension or indeed any of those other steps, you should consider carefully the communication with staff and parents. We would suggest this is likely to be a relatively difficult area as part of this, and the best approach would always be to try to agree what communication is given to staff and parents, explaining the absence of the individual. You would need to manage this sensitively and again be careful about that bond of mutual trust and confidence. In the event that an agreed statement cannot be reached, we would suggest you take advice. At all times, you should be bearing in mind that your obligation is to act as a reasonable employer. So now again, turning to when we get our response from Ofsted in relation to that waiver application, they would write to the individual explaining their decision and the extent of the waiver they are prepared to grant, if indeed they are prepared to grant one. Assuming the waiver is granted, the employer should keep a record and again update their single central register. Assuming the waiver is denied, the individual does have the right to appeal within 28 days of the date of the decision to a first-tier tribunal. Health, Education and Social Care Chamber. Again, a bit of a mouthful. We don't have any indication to date as to how long that appeal would take. As their employer, again, you need to be looking at alternatives as to how you deal with the fact this individual can no longer work in the setting they were originally employed to work in. For example, do you have a way of modifying the role so that they aren't working with children in that restricted setting, or are the other roles available? Or again, can the situation be managed in a different way? Should you eventually reach the point where dismissal appears the only option, then you would need to make sure that you follow your own policies and procedures carefully, and again, bear in mind the obligation to behave as a reasonable employer. Potentially fair reasons for a dismissal in this situation could be illegality, some other substantial reason, or perhaps if it was their own misconduct, which has resulted in them being disqualified, a misconduct dismissal could potentially be an option. We would suggest that you keep careful records of all of your considerations in order to document alternatives that were considered and how you manage the process in accordance with your own policies. As Amy mentioned earlier, we do have a disqualification questionnaire which has been tailored for use in this situation, and we also have a detailed guidance note available on this point, both of which are free and up to date as at today, 12th of March. If you'd be interested in receiving either of those documents, please do contact us. And another way you may want to keep in touch with developments in this area from Muckle LLP would be to join our LinkedIn group, or perhaps to subscribe for our employment or education e-news. Should you have any other questions, or should you want to contact us about this or any other education or employment related matter, our contact details are on screen. Thank you very much for listening. We hope it's been helpful.